Hello, welcome to today's Legal 101. Being a Wednesday, it's on family and succession law, and particularly we are going to talk about oral wills. When one makes an oral will, they're basically saying what they want to happen to their estate upon their demise. They could go ahead and indicate who they want to be in charge of the property and distribute it to the others, and that's what we call an executor. Or they could leave that out but still mention I want property X to go to so and so, property Y to so and so, etc, etc. But for an oral will to be deemed valid, it must be made between two or more competent witnesses. A competent witness is somebody who is of sound mind and is of age. So aside from the oral will being made before the two competent witnesses, the maker of the will must die within 3 months of making that oral will. Now the rules are different for people who work in the armed forces, and if you're one of them, holla at your girl, the inbox is available. Now, something else to consider about oral wills is that they can be deemed invalid if they are inconsistent with the provisions of an existing written will. So if a testator actually made a written will before or after making an oral will, then it's the written will that will take the lead. If in a court of law there is a conflict about whether or not somebody made an oral will, then the court will ask that there be produced an independent and competent witness if they existed. An independent witness is one who is not benefiting from the estate of the deceased person. Regarding procedure for enforcement of an oral will, we know for succession to be done, you have to actually go to court and obtain grants. The form that you will present in court, the petition and the affidavit, will differ depending on whether or not the deceased person named an executor. But ultimately what needs to be presented to court is that the oral will was actually made and when it was made, the terms of the will, the names and addresses of any executors appointed, the names and addresses of all the alleged witnesses before whom the will was made, and whether the deceased at any time executed or caused to be executed a written will. We have just seen why it is important to ask, is there a written will? Now, lastly, an oral will can be revoked or altered by the maker of the will, and this revocation or alteration of a will could be factual or could also be based on circumstances. What was the conduct of this person before they made the subsequent oral will? And so those are some of the things to consider. I know in the African setting it is quite difficult for people to make wills because we feel like we're inviting death, but it is one of the best ways to dispose of your property and ensure there is peace and harmony in your family when you pass away. So I hope you keep that in mind. Share with your parents, with your uncles and aunts, and people in your circles. Share with your workmates. This is something that is quite important for them to think about. Okay, Sawa. See you tomorrow for the last Legal 101 in a while because we're going into Easter. Hallelujah.